Hello, my name's Anna Steiner. I'm a solicitor and senior lecturer at the University of Westminster, where I'm also a supervising solicitor in the legal advice clinic and have oversight of the housing and immigration clinics there. So in this talk, I'm going to concentrate on the law of in relation to homelessness, but will also touch on other areas of housing law in relation to domestic violence. As a bit of background, the latest figures from the crime survey for England and Wales show that in the year ending March 2019, an estimated 1.6 million women aged 16 to 74 experienced domestic abuse in the last year. Domestic abuse is inextricably linked with housing, as abuse most often occurs in the home. Housing is a key barrier to people escaping domestic abuse, and many people who experience domestic abuse often find themselves facing the very serious risk of homelessness if they are to flee the perpetrators, and there is a clear link between homelessness and domestic abuse. So this picture is from a Guardian article written by Josephine Moulds, which was published on the 5th of February this year. She writes that domestic violence is a major cause of homelessness. Government figures show that in the year to June 2019, almost 24,000 people were made homeless in England directly because of domestic abuse. For those fleeing, it is increasingly difficult to find a space in a refuge which offers temporary accommodation and intensive support. Councils cut funding for domestic violence refuges by almost a quarter between 2010 and 2017, and last year, Women's Aid found that 64% of all referrals to refuges were declined. And its 2018 study showed that 45% of people fleeing domestic abuse ended up sofa surfing, and almost 12% sleep rough while waiting for a space to become free. She goes on to write that finding settled accommodation can be even harder. According to the latest government figures, just 2% of households made homeless because of domestic abuse between April and December 2018 were offered social housing. As a result, survivors can face homelessness or returning to their abusers when their time is up at a refuge. This is because councils are only required to provide housing for domestic violence survivors who don't have children or are pregnant if they can prove that they are more vulnerable than the average homeless person. The article quotes the head of policy at Crisis, Hannah Gowsey, as saying it's actually incredibly difficult to prove vulnerability because the evidence required is hard to obtain, and gives an example of one woman who fled her home, saying that she was asked by her housing officer to get a letter signed by her abuser stating that he had raped and attacked her. Now, it's an increasing problem due to the cuts, as alluded to in that article. And Women's Aid, the research that was also discussed in that article, conducted research into the housing conditions and inability to access refuge spaces by women who were fleeing domestic abuse in their report entitled Nowhere to Turn, published in 2018. And their key findings were that 11.7% of the women they surveyed were forced to sleep rough during their search for a refuge, of which 3 of those women were pregnant and 5 had their children with them. Half of those women were forced to sofa surf, and of those, 65 women were sofa surfing with their children. Nearly 1 in 10 of the women surveyed gave up their search for a refuge space and stayed put with the perpetrator, and 1 in 5 women were accommodated in a suitable refuge space through the support of their specialist caseworkers. And that report was compiled from data collected between January 2017 and January 2018. The project also revealed in its second year a widespread systematic failure from statutory agencies such as housing, social care and the police. And of the women supported by the project, 97 approached their local housing team for support. And over half of these women, 53.6%, were prevented from making a valid homeless application, which meant they refused assistance with emergency accommodation. So whilst I'm going to be talking about the law in relation to the duties of local authorities towards homeless women fleeing domestic violence, what the law says and what the Code of Guidance says, which local authorities must have regard to when exercising their duties, are not always adhered to in practice. So, as you can already see, the key issues are a lack of refuge space for women fleeing domestic violence, as well as an inability to be able to access housing through the homelessness route. Now, the law in relation to homelessness is set out in Part 7 of the Housing Act 1996, and local authorities will owe a main housing duty to women who pass certain tests, and in order to qualify for the main duty, they have to be eligible, homeless, in priority need, not intentionally homeless, and have a local connection. And eligibility is defined in Section 185 of the Housing Act 1996, which states that persons who are subject to immigration control are not eligible for housing assistance, subject to some exceptions. So those exceptions would include people who have, for example, been granted refugee status or humanitarian protection. But it leaves a lot of women who are subject to immigration control quite vulnerable, particularly if their immigration status is dependent on their abuser. And I'll talk more about what options they have later on. So what is homelessness? How is homelessness defined legally? Well, Section 175 of the Housing Act 1996 defines a person as being homeless if they have no accommodation available for their occupation which they are entitled to occupy. So they have to have a legal interest in that accommodation. Or a person is homeless because they have accommodation but cannot enter it. For example, they've been locked out of it. Or the most important one here in relation to women fleeing domestic violence is the most common reason is that she has accommodation but it would not be reasonable for her to continue to occupy that accommodation. And there is specific provision in the Housing Act at Section 177(1)(a), which deals with whether or not it's reasonable to continue to occupy accommodation when a person is experiencing or threatened with violence. And Section 177(1)(a) states that it is not reasonable for a person to continue to occupy accommodation if it is probable that this will lead to domestic violence or other violence against her or against a person who normally resides with her as a member of her family or any other person who might reasonably be expected to reside with her. And it goes on to define violence as meaning violence from another person or threats of violence from another person which are likely to be carried out. And violence is domestic violence if it's from a person who is associated with the victim. Now, associated persons are defined in the Family Law Act 1996, as well as in Section 178 of the Housing Act 1996, and they're also set out in the Homelessness Code of Guidance, which is guidance for local authority housing officers that they must have regard to when carrying out their duties under the homelessness legislation. And I'll read out from the Code of Guidance. In the context of defining domestic violence, Section 178 of the Housing Act provides that for the purposes of Part 7, which is the part of the Act that deals with the homelessness duties, a person is associated with another if they are or have been married to each other, they are or have been civil partners of each other, they are or have been cohabitants, or they live or have lived in the same household, or they're relatives, and there's a long list of relatives, people that have agreed to marry each other whether or not that agreement's been terminated, or people who have entered into a civil partnership agreement whether or not that agreement has been terminated. People that have or have had an intimate personal relationship with each other which is or was of significant duration. As well as in relation to a child, each of them is a parent of the child or has had parental responsibility, or if a child has been adopted, one of the natural parents or grandparents of the child, and the other is either the child or any adoptive parent or prospective adoptive parent. So those are persons who are associated persons under the legislation. Now, the case of Yemshaw and Hounslow also dealt with the definition of violence, and that case held that violence includes physical violence, threatening or intimidating behaviour, and any other form of abuse which directly or indirectly may give rise to the risk of harm. And Lady Hale says in her judgment at paragraph 36, she asks, was this in reality simply a case of marriage breakdown in which the appellant was not genuinely in fear of her husband, or was it a classic case of domestic abuse in which one spouse puts the other in fear through the constant denial of freedom and of money for essentials, through the denigration of her personality, such that she genuinely fears that he may take her children away from her, however unrealistic this may appear to an objective outsider? This is not to apply a subjective test. The test is always the view of the objective outsider, but applied to the particular facts, circumstances and personalities of the people involved. And the Homelessness Code of Guidance, which I've already referred to, which is a guidance that local authorities must have regard to when exercising their duties under the homelessness legislation, it deals with domestic violence at Chapter 21. And it says in relation to understanding domestic violence and abuse that housing authorities must take account of the cross-government definition of domestic violence and abuse when designing and delivering services. And this defines domestic violence and abuse as any incident or pattern of incidents of controlling, coercive, threatening behaviour, violence or abuse between those aged 16 or over who are or have been intimate partners or family members, regardless of gender. The abuse can encompass, but is not limited to, psychological, and it reels off a long list of examples, physical, again, number of examples given, sexual, financial, and emotional abuse. It also discusses controlling and coercive behaviour in more detail, giving a full explanation of those. Controlling behaviour is a range of acts designed to make a person subordinate and or dependent by isolating them from sources of support, exploiting their resources and capacities for personal gain, depriving them of the means needed for independence, resistance and escape, and regulating their everyday behaviour. And coercive behaviour is an act or a pattern of acts of assault, threats, humiliation and intimidation or other abuse that is used to harm, punish or frighten their victim. It also defines so-called honour-based abuse and says it's also a form of domestic abuse, explained by the perpetrator of the abuse on the grounds that it was committed as a consequence of the need to protect or defend the honour of the family, and can include all the types of abuse listed above, and specific crimes such as forced marriage and female genital mutilation. And the Code also deals with evidence in domestic abuse cases. At paragraph 20 of chapter 21, it says that whether a threat of violence is likely to be carried out should not be based on whether there has been actual violence in the past. So, despite what the Code says, we've already had the example that was quoted in the Guardian article. I myself have acted on behalf of women in the past who have been turned away when they've approached the local authority for housing because they had not reported the violence to the police or been told that they should go away and get an injunction before making an application. So it's important to know that this is what the code says, and this can be referred to when challenging refusals to accept applications or unfavourable decisions that have been made for women who've applied as homeless after fleeing violence. It's not necessarily always what happens in practice. Now, other areas of law that also come into play and can be very relevant in cases where a woman is fleeing domestic violence, for example, family law in relation to obtaining an injunction, child law in relation to making arrangements for the children, property law in relation to transfer of property, immigration law, for example, if a woman's immigration status is dependent on her partner whom she is fleeing because of domestic abuse, and of course criminal law. So important to bear these in mind as well. Of course, the first objective for a person fleeing domestic violence or their advisor is ensuring the woman's safety. And there are a number of legal and practical steps that can be taken on an urgent basis, such as using family law to apply for an occupation or non-molestation order. However, for many women, staying in their own home is far too dangerous, so she will either leave and stay in a refuge or with a family member or friend. There are a number of organisations that can help women to find a refuge place, such as Women's Aid and Refuge, and advice and assistance with obtaining an injunction can be obtained from the National Centre for Domestic Violence. Once a woman is in a refuge, is she still homeless? Well, the case of Moran and Manchester held yes, and Lady Hale at paragraph 65 said the important principle established here is that in most cases a woman who has left her home because of domestic or other violence within it remains homeless even if she has found a temporary haven in a woman's refuge. So how does a woman fleeing domestic violence apply for housing as a homeless person? Well, as I've said, the relevant law in relation to the duties owed by local authorities to homeless people is set out in Part 7 of the Housing Act 1996. And the official statistics for England showed that in 2017, 6,850 people were accepted as homeless by their local authority because of a violent relationship breakdown, which accounts for 12% of all the homeless acceptances that year. And whilst this is a significant number, it only includes the people accepted as homeless and owed the main homelessness duty. So this, alongside the hidden nature of many women's homelessness, as I mentioned previously, the hidden homeless, those sofa surfing, staying with friends and family, and a reluctance on behalf of some women to report abuse, means that this figure is an underrepresentation of the true scale of the problem. The Homelessness Reduction Act 2017 made a number of important changes to the way in which local authorities are required to respond to homelessness, by way of introducing the assessment, prevention and relief duties. These are duties that are owed to all eligible homeless people, whether or not they are in priority need or intentionally homeless. The assessment duty requires a local authority to carry out a housing needs assessment and draw up a personal housing plan whilst they continue to investigate a woman's homelessness application. The assessment must include all the circumstances that cause the woman to become homeless or threatened with homelessness, as well as her housing needs. and what accommodation would be suitable for her and any persons who live with her or could be expected to live with her, as well as the support that she would need, or anyone who's living with her will need, to have and sustain suitable accommodation. So this personal housing plan, which is drawn up as part of the assessment, should be agreed with the applicant woman and kept under review. The prevention duty is a duty that applies to women who are threatened with homelessness, and the Code of Guidance states in Chapter 11, paragraph 27, that wherever possible and appropriate, housing authorities should prioritise efforts to prevent homelessness so that households can remain in their accommodation or help to secure a new home rather than becoming homeless. So the aim of the Homelessness Reduction Act was, well, what it says on the tin, to reduce homelessness, and this duty, the prevention duty, was introduced to require local authorities to take steps to assist a person from to prevent homelessness effectively. So how does this work in relation to domestic violence? Well, it's dealt with in the Code of Guidance at Chapter 21, which says, following an application for assistance under Part 7 of the 96 Act, whether an applicant is threatened with homelessness or is actually homeless will be a matter for the Housing Authority to assess, taking into account all of the relevant circumstances. For example, a person at risk of domestic violence or abuse may be threatened with homelessness because a perpetrator is soon to be released from custody, and so the person is likely to become homeless within 56 days, but would be actually homeless if the perpetrator was in the community and presented a risk to them at their home, and so it is not reasonable for the person to continue to occupy accommodation. It goes on to say that when a local authority is developing a personalised housing plan, they should be particularly sensitive to the applicant's wishes and respectful of her judgment about the risk of abuse, and that victims should be allowed sufficient time and space to absorb and understand the options available to them. Now, Chapter 21 does also talk about reasonable steps that a housing authority might take to help an applicant to retain or secure safe accommodation, and these include provision of a sanctuary scheme or other security measures. Now, sanctuary schemes were introduced several years ago in an effort to help to keep women who are being abused in their own homes. So the local authority housing team would organise perhaps a secure door and a heavy duty lock and a panic button to be put into a room in the woman's home. It also talks about prevention, including assistance in finding alternative accommodation or helping a woman to access legal remedies such as injunctions where they might be effective. And talks about helping single people to gain more support from family and friends. The Code does go on to concede that the use of sanctuary is not appropriate, the use of the sanctuary schemes I referred to a moment ago, where enhanced security measures are put into the home. They're not appropriate if the perpetrator lives at or retains a legal right to enter the home, or if the victim continues to be at risk in the vicinity around the home. Now, you can imagine a lot of women would not feel safe if they simply had a room they could flee into, where they could press a panic button, for example, that went directly to the police station, or indeed if the extra secure door was put up as an external door if it was a home that the perpetrator did not have a legal right to occupy. So that is conceded in the guidance. It also talks about housing authorities informing applicants of the option of seeking an injunction, but says that they should recognise that injunctions may not be effective in deterring some perpetrators from carrying out further violence, abuse or incursions, and that applicants may not have confidence in their effectiveness, and that consequently applicants should not be expected to return home on the strength of an injunction. To ensure applicants who have experienced actual or threatened violence get the support they need, authorities should inform them of appropriate specialist organisations in the area, as well as offering counselling and support. The code also says when dealing with domestic violence and abuse within the home, where the authority is the landlord, housing authorities should consider the scope for evicting the perpetrator and allowing the victim to remain in their home. However, where there would be a probability of violence if the applicant continued to occupy their present accommodation, the housing authority must treat the applicant as homeless and should not expect them to remain in or return to the accommodation. And importantly, the code states, in all cases involving violence, the safety of the applicant and her household should be the primary consideration at all stages of decision making as to whether or not the applicant remains in her own home. So that's the prevention duty. There's also the relief duty, and this, along with the assessment and prevention duty, is owed to all homeless applicants, whether or not they are in priority need, as long as they are eligible and homeless. So a relief duty is owed where a local authority accepts that the applicant is homeless, and the duty is to take reasonable steps to help an applicant to secure that suitable accommodation becomes available for her occupation for at least 6 months, and that's set out in section 189B of the Housing Act 1996. In so doing, the local authority must have regard to their housing need assessment and the personal housing plan. Now, the relief duty is only a temporary duty. It ends after 56 days. It could be brought to an end by a number of other factors, such as an unreasonable refusal to cooperate or refusal of a suitable offer of accommodation before the end of 56 days. It also ends automatically after 56 days when the main housing duty is owed. So that's when a woman has had her homelessness application investigated and assessed, and the local authority accepts the duty because she is eligible homeless in priority need and not intentionally homeless. But there is also an interim accommodation duty owed to all persons who are eligible homeless and in priority need. And this is set out in section 188 of the Housing Act 1996 in respect of the duty to provide accommodation to women who have applied as homeless who appear to be eligible homeless and in priority need. The section states that if the local authority has reason to believe that an applicant may be homeless, eligible for assistance and have a priority need, it must secure that accommodation is available for her occupation, with the aim here that she's accommodated while the local authority carry out the necessary inquiries to satisfy themselves that she's eligible, homeless, priority need, and not intentionally homeless. So the relief duty is triggered at the same time as the interim accommodation duty for a person who appears to be in priority need. And I've already said what the full housing duty is when that's owed, but this can be discharged in a number of ways, including an allocation of a housing association or council tenancy under Part 6 of the Housing Act 1996, or it could be discharged by arranging what's called a private rented sector offer. That is an offer of accommodation in the private sector for a fixed period of at least 12 months. So what is priority need? Well, this is set out in section 189 of the Housing Act 1996. So a woman who's pregnant or has dependent children will automatically be in priority need. It also talks about people who are homeless as a result of an emergency, such as a fire or a flood. That would not, it does not include violence. Young people aged 16 and 17 who are not in care, young people aged 18 to 20 who are care leavers, but the most important one here, the most common category for women fleeing domestic violence who are not pregnant or have no dependent children, is women who are vulnerable as a result of violence or threats of violence. And you recall that that test was discussed in the Guardian article, and it is a hard test. It has quite a high threshold. Now that requirement of vulnerability as a result of violence or threats of violence only applies in England. In Wales, a woman fleeing violence is automatically in priority need, whether or not she has dependent children or is pregnant. In Wales, as long as she's fleeing violence, she's in priority need. She does not need to prove vulnerability, as women in England are required to. So what is vulnerability? Well, as suggested by the articles and research mentioned earlier, this is not easy to prove. The strict legal definition as set out in the Homelessness Code of Guidance in Chapter 8 is that if a woman is vulnerable, defined as vulnerable, if they were homeless, would she be significantly more vulnerable than an ordinary person would be if they became homeless? So this definition was arrived at after the cases of Hotak and Paniotu, where there was much discussion of the test and the comparator. So the comparator is not a hypothetical or actual ordinary homeless person, it's an ordinary person if made homeless. And it's a qualitative, not a quantitative test. So at paragraph 64 of the judgment in Paniotu, it says the question to be asked is whether, when compared to an ordinary person if made homeless, the applicant, in consequence of a characteristic within section 189 1c, that's the priority need categories of vulnerability, would suffer or be at risk of suffering harm or detriment which the ordinary person would not suffer or be at risk of suffering, such that the harm or detriment would make a noticeable difference to her ability to deal with the consequences of homelessness. So as you can see, that's not the most straightforward test. And support from others can be taken into account when considering vulnerability. So if, for example, a woman does have support from a charity, for example, or a friend or family, that will be considered when deciding whether or not they would be at more risk of detriment than an ordinary person if they were made homeless. So the local authority must assess the homeless woman's vulnerability if she is not provided with accommodation. So as you can see, the threshold is high, and even if a woman has dependent children or is pregnant, so obviously in priority need, she may be turned away by a local authority doing what is known as gatekeeping, and I'll come back to that in a moment. But just to refer to what the Code of Guidance says about how housing officers should decide on vulnerability in relation to women who are vulnerable as a result of fleeing violence or threats of violence. In Chapter 21 at paragraph 34 it states factors that the local authorities may wish to consider when deciding whether the applicant is vulnerable, such as the nature of the violence or threats, the impact and likely effect of the violence or threats on the applicant's current and future well-being, and whether the applicant has any existing support networks, such as family or friends, as I mentioned a moment ago. Also, if there's a continuing threat from the perpetrator. And the code also states that the housing authority should determine whether, if homeless, the applicant would be significantly more vulnerable than an ordinary person would be if they became homeless. That's the same test I referred to a moment ago. So, as I was saying before, the threshold is very high, and even if a woman has children or is pregnant, so obviously in priority need, she may well be turned away by a local authority doing what is known as gatekeeping. And I mentioned earlier that the Nowhere to Turn report produced by Women's Aid, publishing their research into experience of women who were experiencing violence and seeking places in refuges. 97 women, of the 97 women who approached their local housing team for support, for 53.6% were prevented from making a valid homeless application. So by being prevented from making a valid homeless application, they were simply turned away, told that they weren't eligible. And the table on this slide sets out the various reasons that were given to the women surveyed for being prevented from making a valid homelessness application. So you can see that out of the 52 women who were prevented from making a homeless application, 12 were told they were not in priority need. So that's before any assessment has been carried out. 8 were told they needed to produce proof of domestic violence, and we've already talked about what the code says about that, but nevertheless these women were turned away being told they needed to bring in proof of domestic violence. 7, they were told they needed to apply to another borough. Well, I'm going to come on to talk about local connection, and whilst a local authority only has a duty to house people who have a local connection with that local authority, that does not include women who are fleeing violence. So a woman who's fleeing violence can apply to any local authority, and in fact the assessment duty applies to all local authorities. A person can apply to any local authority as homeless and they should be assessed. So again, here people were turned away when they shouldn't have been. 6 of them were told to call the National Domestic Violence Helpline. 5 were not even given a reason. 5 were told they were intentionally homeless. 3 were told to return to the perpetrator. 2 were told they were not at risk of homelessness. 1 was asked to provide identity. 1 was told she was not at risk because the perpetrator was on remand. 1 was told that the duty had been discharged because she hadn't accepted accommodation that was offered to her, and 1 was told that she couldn't complete her application if she was looking for a refuge. So we can see that whilst the law and the Code of Guidance state what should happen in relation to women applying as homeless to local authorities. It's not always what happens in practice. So what about other issues? I talked earlier about the eligibility requirements. So for someone to be eligible, there must be a person who's not subject to immigration control, with some exceptions. And those people will also not be eligible for public funds. So women who are subject to immigration control and have no recourse to public funds will have difficulty in obtaining a refuge space because they won't be entitled to benefits to fund that space. They won't be eligible to apply as homeless. So where can they go for help? And their only option may be to seek help from social services if they have children or have community care needs. Social services have a duty towards destitute families under Section 17 of the Children Act 1989, under which every local authority has a general duty to safeguard and promote the welfare of children within their area who are in need, and so far as is consistent with that duty, to promote the upbringing of such children by their families. So services provided may include providing accommodation and giving assistance in kind or money. If somebody has community care needs, so adults without children may have needs for care and support, they might be provided with accommodation by social services under their duties set out in the Care Act 2014. So we've talked about the lack of refuge spaces. Other issues that often arise are around accommodation being provided outside a woman's local area. So this can apply to both relief accommodation provided under the relief or interim duty, as well as in relation to longer term accommodation if the full housing duty is owed. So there are sort of two sides to this. If accommodation is provided outside a woman's local area, that can cause difficulties for her in relation to, for example, her children's schooling. They have to travel a long way to go to school. She will be far from her support networks, friends and family, maybe from her employment, from any other supports or services that she has. But for some women, they may want to be housed, whether that's on a temporary or permanent basis, outside of their area and far from their abuser. Now, I talked about local connection a while ago, and that ordinarily, in order to be eligible for the main housing duty, a homeless person needs to have a local connection, but that requirement doesn't apply if somebody is fleeing violence. So what is a local connection? In relation to personal housing plans, the Code at Chapter 21, Paragraph 26 states that local authorities should be particularly sensitive to applicants' wishes and respectful of their judgment about the risk of abuse. And again, with the accommodation provided under the relief duty, considerations this should be considered. So under the local connection provisions, the main housing duty can be referred to another local housing authority, as can the relief duty. And as I said earlier, an applicant can apply to any local authority as homeless. And for someone who's threatened with homelessness, the prevention duty must be performed by the authority to which the application is made, but a referral to another local authority can be made at the relief stage. So if the local authority is satisfied that the applicant is homeless and eligible and owed the initial duty and the initial relief duty, if that person has a local connection with another local authority. So what do we mean by local connection? So this is set out again in the Housing Act, and a person may have a local connection on the grounds of normal residence, i.e. that's where they've lived for some time, their employment, family association, special circumstances, they've left care, or a former asylum seeker may have a local connection if they were provided with accommodation in an area. But the Code of Guidance does advise local authorities that they should consider each case individually on its own particular facts. So, as I said, a local authority can refer a case to another authority if an applicant does not have a local connection to the authority to which they applied, and they have a local connection with the other authority, and there is no risk of violence in the other district. And this is also set out in the Code at Chapter 21, paragraph 38, where it says a housing authority cannot refer an applicant to another housing authority where they have a local connection if that person or any person who might reasonably be expected to reside with them will be at risk of violence and abuse in that other district. The housing authority is under a positive duty to inquire whether the applicant would be at such risk, and if they would, it should not be assumed that the applicant will take steps to deal with the threat. Another possible solution for women who are already tenants of a local authority or a housing association, and the tenancy is in their name alone, right, it's their sole tenancy, is provision of temporary accommodation and then a management transfer. So the housing authority would organise for another tenancy to be granted to the woman, and she would be provided with temporary accommodation while she's waiting for that to be organised. So location is relevant, as I said, in two ways. It could be that it's relevant in terms of local connection, and a woman may want to stay in her local area, or she may feel safer being in another local authority, and her wishes and assessment of her safety should be taken into account when deciding whether or not to offer her housing. But it's also relevant in terms of suitability. So accommodation, all accommodation, both temporary and longer term accommodation, if it's being provided under the main housing duty, must be suitable. And that's dealt with in the Code of Guidance at Chapter 17 and in the Homelessness Suitability of Accommodation Order 212, which requires local authorities to take account of location when determining suitability. And where accommodation is outside the district, the significance of any disruption which could be caused by the location of the accommodation to the employment, caring responsibilities or education of the person or household members. The proximity and accessibility to medical facilities and other support that are essential to the well-being of the person or a member of their household. And the Housing Act 96 at section 208 provides that as far as reasonably practicable, a local housing authority shall, in discharging their functions, secure that accommodation is available for the applicant in their district. And the Code of Guidance also recommends that where possible, accommodation should be secured as close as possible to where a person was previously living. However, despite all of this, the pressure on local authorities does mean that authorities, especially local authorities in London, frequently place people in accommodation outside of their own area and outside of London. So let's now think about the situation in relation to allocations under local authorities' individual allocation scheme. So each local authority maintains a housing register, and some of the people on that housing register will be people that they've accepted a duty to house under Part 7 under the homelessness legislation. Others will be people who are on the housing register, the waiting list for housing. And each local authority is entitled to decide on the qualification criteria for their housing register. They are obliged to have reasonable preference to local people. And a number of housing authorities will include a residence requirement or some other qualification requiring a connection with the local area. The case of Queen and Ealing held that Ealing's allocation scheme residence criteria was unlawful because it indirectly discriminated against female victims of domestic violence. So it was a case where a woman from outside the local area had applied for housing under the allocation scheme, but was told that she didn't qualify because she hadn't sufficient residence in the area. The statutory guidance for local authorities in respect of providing housing for local people states at paragraph 19 that it's important for housing authorities to retain flexibility in order to take account of special circumstances, which can include providing protection to people who need to move away from another area to escape violence or harm. So a woman should not be excluded from an offer of permanent housing under a local authority's allocation scheme simply because she is from another area, and any decisions that she doesn't qualify could be challenged in the same way as the decision in the Ealing case referred to was. So let's just think about other possible solutions for women. We've talked about applying as homeless and qualifying for longer term housing under the main housing duty owed to homeless persons, and very often that is discharged by way of an offer of accommodation under the allocation scheme, but increasingly it is also discharged by way of a private rented sector offer. That's a privately rented tenancy for a minimum period of 12 months. But some people may want to return to their home or stay in it. So let's just turn to those possibilities. What can people do in those situations? So let's think about it in relation to tenants first of all. So where people are married or in a civil partnership, there is a long established right for a spouse to occupy the matrimonial home. These were formerly known as matrimonial home rights, but now are known as home rights, and they relate to civil partners as well as married partners. So a person has a legal right to occupy accommodation that is solely owned by his or her spouse or civil partner, provided that it's been their shared home during the marriage or civil partnership, and that right's set out in the Family Law Act 1996 at section 30. So in a situation where a couple are married and the woman wants to remain in the home, she may be able to get an occupation order excluding her abuser from the home. It may be possible for her to get the tenancy transferred into her name together within the divorce proceedings. under the Family Law Act 1996, and she could also use the Matrimonial Causes Act 1973. Where a couple is cohabiting and they're tenants, if the tenancy is in the sole name of the other person, the other party in the relationship, the abuser, the woman who is not the tenant has no automatic right to occupy, or if she is the sole tenant and the abuser is not named on the tenancy agreement, he or she has no automatic right to occupy, so they could be excluded by way of an occupation order, and they would have no right to enter. They're simply a licensee. If both partners are tenants, as joint tenants, they both have a legal right to occupy, and the tenancy could be transferred into one partner's name, and similarly an occupation order could be obtained. In relation to owner-occupiers, so similar to the situation for tenants, if they were married or civil partners, the Family Law Act 1996, they could apply for an occupation order, transfer of liabilities and transfer of property as part of the divorce proceedings. But the occupation order, of course, could be applied for on its own. Where you have a cohabiting couple and the sole owner is the abuser and the woman who wants to remain in the property has no legal rights of ownership of the property, she would normally not have an automatic right to occupy. She'd simply be a bare licensee, but it may be possible to apply for the transfer of ownership of the property under the Children Act 1989. If they are joint owners, they're both entitled to occupy the property, but again, it may be possible under the Children Act to apply for a transfer. Just briefly before we close, I'm just going to talk about the Domestic Abuse Bill, which is a bill that is before Parliament, which will create for the first time a cross-government statutory definition of domestic abuse to ensure that domestic abuse is properly understood, considered unacceptable and actively challenged across statutory agencies and in public attitudes. So there is a lot that is great about the bill, but there are some things that are missing. It redefines domestic abuse, and for the purposes of the bill, it defines domestic abuse as the behaviour of a person A towards another person B as being domestic abuse if A and B are each aged 16 or over and are personally connected to each other, and the behaviour is abusive. It says behaviour is abusive if it consists of any of the following: physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, or psychological, emotional or other abuse, and goes on to give further definitions. But for all that the Domestic Abuse Bill does, there are some things it doesn't do, and a number of organisations, campaigners and people who are being consulted recommend that it does go further and remove the requirement for those leaving domestic abuse who are not in priority need by virtue of being pregnant or having dependent children to be vulnerable, so that we would have parity with Wales, and a woman fleeing domestic violence would automatically be in priority need. There are also recommendations that the bill introduces a statutory requirement for refugees to be provided, and that local authorities are prohibited from relying on residence or other qualifications in their allocation scheme that exclude those leaving domestic abuse. So thank you for listening, And if you do have any questions, as if this was a live lecture, I would normally take questions at this stage, do by all means feel free to drop me an email.